So I will say this part is my opinion, and the reason I'm saying it as this, because it's going to be very strong compared to just reading court documents and reading you stuff and interpreting what it means. If the goal of the client here is they don't want to be doxxed, they don't want their name, information becoming public. They decided, so giving you a little background, Ethan Klein in the Denon's case decided to move forward with a subpoena to Reddit and Discord. It is not confirmed or even known if Reddit or Discord would willingly turn over the information. They may not. There are rumors of connections with Reddit moderators, and there's other things at play. But in the H3Snark genius move, they decided to hire a lawyer. This lawyer did not go to law school. That is relevant for the reasons I said in the other video. But in law school, you have the leading experts in any of the fields you choose, immigration, patents. You have my patents professor. He was busy. He can only teach at nighttime because he was busy in the daytime doing patents. So you do have experts in this field who have experience, have articles. My First Amendment professor, Professor Van Austin, was the expert in the First Amendment before he passed away. Rest in peace. So they can tell you how to write a declaration, what evidence to include, how long it should be. This lawyer, in my personal opinion, has made a massive mistake. So from point one, you have to follow me on point one. If you don't understand point one, you're not going to understand the logic behind this. Point one is these individuals from H3Snark mod team, they do not want to be identified. They feel like being identified will ruin their lives. They will not get a job. They'll go bankrupt. Their family will disown them. All these catastrophic things will happen to them. So they're very desperate not to get identified. This lawyer has written this. Some details, including personal medical details and details which could be used to identify those, have been excluded. This is in the Jane Doe Declaration, page 2. So out of 158 pages, one of the very first things they said was we're excluding some details, like personal details, medical details. I do not know why the medical details matters, but I guess it does matter because that they're mentioning here. I would imagine that it would be strange to even say this. Those would only feel comfortable submitting the excluded portions to the court in camera for confidential review. What they're saying is, hey, well, we have other evidence, but we can't send it. We can't make it public because it would expose us. But if you want to see the other evidence, we can show it to you in camera. Now, in camera, this evidence can be made public. I don't know if this was explained to the Does, but the judge has very broad. So if the whole concept is we have to keep our identities secret, the judge receiving this 740-page document, not once but twice, receiving an unknown sized USB, which implies to me that it was so large that they couldn't even put it into 740 pages, is watching whole live streams, hours and hours of live, being forced legally to watch these live streams, again, because the judge has to make a recommendation. How can they make a recommendation if they haven't reviewed all the material they were given, right? Then the movants, the H3Snark, would be like, oh, well, clearly you didn't read page 520. In 520, I had this argument, and you didn't even read it. So how could you make a recommendation on it? That's what they're going to say, right? Because that's what they always say. Oh, well, the judge didn't understand my argument, or the judge didn't read my argument, or it was out of context. Those are the things that you appeal. Judges are very afraid of appeal. Magistrate judges give a recommendation to a district judge, and they do not want their recommendation to be shot down. They don't want the district judge to be like, oh, well, they're right. You didn't read page 510, paragraph 2. With a link to the 5-hour live stream. You really should have watched that live stream, magistrate judge, because how could you make a recommendation without it? Anyway, I'm going to go straight to the point here. This lawyer has put them more in jeopardy had they done nothing. I think they have a much better shot of Reddit and Discord rejecting it, right? With all the rumors and the rumors are rumors, right? But maybe there's some truth in it. But even excluding all the rumors about Reddit mods being employees, of Reddit and so on, Reddit is just not. This is the Reddit model. People would feel confident. They would do a lot less snark posting if they knew Reddit would turn over their names during a lawsuit, right? Which is not good business for Reddit because Reddit wants you to post as much as possible. That's their business model. Here, we have to remember that. Now I'm going to dig into the lawyer, and I've already said it's my opinion. This is really poorly written. Page 2 of the Jane Doe Declaration basically says, hey, we have information that's relevant, but we are not going to share it with you. We're not going to share it with you unless you ask for it in-camera review. And at that point in time, they can make it public. So I don't know if there's a misconnection here, right? Like, so who would you rather determine to turn over information? Reddit and Discord, who do care about privacy of usernames, or a judge who just simply wants to get the copyright case over? Remember, this is a contributory copyright negligence case. Whether or not the names have to be turned over depends on if there is a case. If there is no case for contributory copyright negligence, then the names don't have to be turned over because it is moot, right? It doesn't make a difference. You're not going to sue them anyway. You need to sue them because you need their names. So if you win, you need to know who they are so you can garnish their wages, so you can go to their place of employment and potentially contact the employer and say, hey, the court will do that for you, but then your employer will be like, hey, why are we getting the wages garnished? This type of stuff, when it becomes public, is public, okay? When Reddit turns over information, they could probably stop, maybe to get the information, Ethan has to sign an NDA not to make the information public, but only to really use it in a lawsuit, which then he would sue using the names. But there might be other information, personal and medical, that would never make it publicly. But here, everything is at stake. They have done a very bad job. The lawyer has done a very bad job explaining the situation to them. It is, in my opinion, they would have been much better off doing nothing and letting Reddit and Discord decide if they want to turn over the information. And even if the information, I don't know what the information could be, but it may be that they turn over the information to Ethan and he can't do anything with it, right? They're using IP, VPNs. It's hard to, I just cannot imagine a scenario unless they have their credit card information on file where they would know where to live. So he needs to know where to live so he can serve them. He needs a recent address to serve them, the legal paperwork, and he also needs their names, of course, to sue them. You can't sue a Jane Doe because even if you won for damages, how would you recover the money? Here, they went to a lawyer, a law firm, and they told them their real names. That lawyer, law firm, now I am certain they know who they actually are. And that lawyer just wrote on page 2 of the Jane Doe Declaration, or Jane Doe wrote this, and the lawyer didn't stop her. Hey, we have all this information that could expose who we are. We don't want to share it, Ethan, but we can share it with you, because you won't do anything with it, right? Oh, no. Oh, no. So if the judge finds out that this information is relevant to Ethan and his legal team, again, they're not they're the plaintiffs, of course, then he gets it all. Not only does he get it all, I get it all, because it becomes public. It will get posted on Court Listener. It'll get posted on LexisNexis. It'll get posted on Westlaw. And then everyone knows your information. And people go, oh, that's doxing. That's just how the law works. You cannot sue someone. Imagine a world where, like, you're suing Jane Doe or New Master 69, right? Like, the whole court system would just fall apart if you couldn't sue real people and you were just suing usernames. How would you get your money? The answer is you wouldn't get your money, right? You just be wasting your time doing nothing. And the court system, the one thing courts will tell you, the one thing law professors will tell you when you write your law essay at the end of the term to get your grade. Many of these essays are 100% of your grade, by the way. Keep it short, keep it to the points, the facts, and the arguments that you want to make. Anything longer than that is wasting my time, it is wasting your time, and in real life, it will waste a judge's time. No one in the legal system has time to waste. That's why everyone's billable hours are so high, and especially the judge, because the judge has so many cases on their docket, and they're expected to handle cases like this, and they're expected to get this case done relatively fast. Because if they're unfortunate, again, every case is different, right? This is obviously a very unique case for this judge, but I'm certain that the judge is, and then the judge will never say this, I'm certain that the judge is not happy with the length, because no one should be happy with the length, not even the move-ins. I guess if your billable hours are high, yeah, I guess it could be not great, but still, I mean, you just have to listen to this snarker talk all the time, but you're billing her or him for every hour they're talking. Okay, I guess the only person really, really happy is the H3Snark lawyer. Should they be charging per hour, right? Then they can listen to this H3Snarker go for hundreds of hours, right? Because I'm just going to, I mean, it's easy. I'm just listening to a story. My conclusion here is this lawyer has put the H3Snarkers in massive danger of being exposed of who they are. Because not only does the lawyer and law firm know who they are, previously the only people who knew who they were or who had information was Reddit and Discord. And again, I don't know what type of information Reddit and Discord have where they have to try to prevent this. But I cannot imagine it's like that easy to identify someone from an IP address alone, right? Because there's multiple people. Maybe it's an apartment complex, right? Maybe it's like apartment Wi-Fi, or I don't know, McDonald's Wi-Fi. Like, how would you really? It seems like it would be very difficult to identify someone from any information Reddit or Discord could give, unless they have a credit card on file. But in addition, that was the only person who could give information, and they probably don't know their real names and addresses. I can tell you one person who knows their real name and address, Leia. I can tell you a bunch of people at the law firm, paralegal, secretaries, who know the names and addresses of these Jane Does. And I can tell you somebody else who's going to learn about it on October 28th at the latest, and it would be the judge. The judge that you just dropped 740 pages on, not once, but twice. The judge that you just dropped a USB on. A judge where 99% of the content, I really think this thing could have been done in 7 pages or 8 pages. I'm saying for every 100 pages they generated, it could have been summarized legally in a 1 page. So I'm putting myself out there as my opinion that 99% of this document could have been cut away and nothing would have been lost. Nothing of significant value to the question about contributory copyright infringement would have been lost. That's the guy, that's the judge that is now going to determine if your medical information, if your personal information is going to be made public for everyone to see. This seems like a very bad move, but hey, I went to law school, so what do I know, right? Bye, guys. Oh, leave me a comment if you have any questions. There's so much to go over on this because it is so. My opinion is the billable hours on this project are very high if they're charging per hour. And I've seen this time and time again when lawyers do a disservice to their client's ultimate goal. So when my client had a $40,000 contract issue, the issue is they don't want to pay $40,000. So then they pay their law firm almost $300,000 not to pay $40,000. Well, what was the main objective was they wanted to save money. So the objective was not achieved when you're paying your law firm almost 10 times the amount of money. Had you just default judgment, you would have paid $40,000. They ended up paying a little less than $220,000 because I saved them a lot of money on the back end. So, what is the objective of these H3Snark mods? They don't want their identities to be known. Yet they went to a lawyer. That lawyer knows the identities. They went to a law firm. They know the identities. They went to a judge, and now that judge knows the identities. And at any point in time, the judge can be like, you know what? Your privacy isn't that important to me. This information is relevant to Ethan Klein's. And the Ethan Klein legal team needs to know this information to come up with a response. Horrible, horrible mental lapse. Anyway, hi guys.